Enoch Burke here, standing in Castlebar. As you know, today the Court of Appeal issued its judgment in my bias case. I won the case. It's a judgment to be welcomed. The judgment related, of course, to my case of bias against Mr. Kieran Christie, the General Secretary of the STI. That's the Association of Secondary Teachers in Ireland. It's the largest teachers' union of secondary school teachers on the island of Ireland. As many of you will know, back when I was purportedly dismissed back in 2023, a panel was assembled to hear my appeal, and one of the nominees in that panel was Mr. Christie, the General Secretary of the STI. Now, I took objection to that. As you will recall, back in August 2022, when this whole case arose, just a week and a half later, the ASTI came out to the Sunday Independent and spoke to the media and said that certainly they would advise schools to use the pronoun that a child wishes to be used. A startling comment. And of course I took objection to this, and because Mr. Kieran Christie would not step aside from the panel, I was obliged to bring a bias case to the High Court. Now, Judge Conor Dignam heard that case back in summer, just this time in summer 2023, 2 years ago. And when he delivered judgment on that case, quite shockingly, he found that I was not disciplined for my religious beliefs or because I expressed an objection to the principle, but simply for the manner in which I had objected. And he ruled that the substance of my objection was therefore not an issue to be addressed by the DAP, and therefore that no objective bias case was made out. Absolutely startling. And I would say at this juncture that when I received that judgment at Christmas 2023, I was sitting in a prison cell on a prison bed, and it was very shocking to be told by a High Court judge that something that was absolutely clear and obvious on the face of the principal's report was not actually the case. The principal had made absolutely clear that I was being disciplined. She said he has stated his personal views on transgenderism in school, that it was because I objected to the principal's instruction. And to be told by Mr. Kieran Christie, by Judge Conor Dignam, that the General Secretary of the STI, who had come out 1.5 weeks later and said use the pronoun that a child wishes to use, was not objectively biased, that was astounding. A child would have been able to tell you that there was a case of objective bias there. So moving to today, to this result, the Court of Appeal has ruled now today, almost 2 years later, that Judge Dignam was wrong. That the substance of my objection to Principal Niamh McShane's demand was a factor in my dismissal. That is the judgment of the court this day, that was central to my dismissal. And that because of that, the DAP must rule on the legitimacy of the principal's demand. It must rule on that, the rights and wrongs of whether she was entitled to make that demand of me. The Court of Appeal has said, and I quote, that the principal's instruction is a kernel of the disciplinary case against me. Now, this has very important implications going forward. It means that the DAP must look this issue in the face. It must address the legitimacy of the principal's demand, something that the courts have refused to do from the start until today. This is simply what the principal's report said, of course. Right from the beginning, it was laid before the judges, and they have refused to acknowledge it. And it's a great relief today to be told that Judge Conor Dignam was wrong, and to hear the Court of Appeal admit at last that this case is about teachers in Ireland across this country being compelled, being instructed to affirm transgenderism and to use the they pronoun. For the very first time, the Court of Appeal has finally admitted that this is what this case is about. Now, of course, this hasn't happened easily. It's taken 3 long years, a very long and hard fight to get to this point. And I do believe in my heart that the only reason the Court of Appeal has done this day is because it was forced to do this. The evidence was absolutely overwhelming. It was laid before the court. It had no way out. It had to acknowledge the evidence that was before it. It couldn't do otherwise. It just had to do that. And that is why it has come out today as it had. But I would say that it's a terrible state for the country to be in, for the courts in the country to be in, that it has taken so long for the courts to acknowledge this. It has been 3 long years since that principal's report was written and since it came before the court. And my mind goes back to August 2022 when this matter first came into the High Court. It came before Judge Siobhan Stack. And what she said when the report was laid before her was, she said that it was about the manner in which Mr. Burke has expressed his views and not the actual views themselves. The opposite of what the Court of Appeal has now ruled on today. On that first day, the truth simply wasn't told by the High Court. And similarly, in 2023, the following year, a judge of the Court of Appeal, Mr. Justice John Edwards, stated categorically in his judgment, he said that there was no evidence whatever that Mr. Burke was placed on administrative leave because of the views that he holds. That's what he said. The exact opposite of what the Court of Appeal has found today. He said there was no evidence whatever that it was about my views. I think that's very startling. This is a judge that's continuing to sit on the bench today. His only role, his only job is to administer justice, to know the law, to know the facts, and to state them truthfully and to apply the law to that. He's getting well paid for that. That's what he's getting his €250,000 salary for. That's his profession. And it's very startling that he would have made that comment. And I would say that I would have had to suffer for years, as I did, through imprisonment, through a denial of justice, because that judgment was made by Mr. John Edwards of the Court of Appeal. That is a very sad state of affairs for our country to be in. And I know today, of course, that the Court of Appeal is refusing to give me my costs in this matter. Of course, when you go to the High Court and then to the Court of Appeal, costs are generally a very substantial part of the there's a very considerable outlay that's made. Courts are refusing today in the judgment to give me that. I note that. And of course, why are they refusing? Well, of course, it goes back to the very beginning in this matter. And from the very start, the court, and even now, is refusing to acknowledge that I have been denied my constitutional right to freedom of religion. That's what the court's refusing to be acknowledged. There's been imprisonment, of course. There's been denial of that. Lies have been told by judges. There's been a covering up of the facts. And of course, my salary has been taken from me. As you can see behind me here, where I stood some months ago, stating that my bank account of €40,000 has been emptied. That money hasn't been given back to me. And every month now, €3,000, my entire salary is taken from me. What happens is I don't see the money. I get a pay slip, but I don't see the money. The money never reaches my account. It's simply taken from me. That's taken from me. My salary, €1,500 every 2 weeks, €3,000 every month, taken from me. My bank account emptied by the Attorney General, Rossa Fanning, working with the courts, working with the Minister of Finance, Pascal Donoghue, and the Minister of Education, Helen McEntee, to strip me of my assets. Why? Because I insisted on, as every citizen should do when they come before the courts, my constitutional right to freedom of religion. So you might wonder, why is all this happening? And well, I believe that one of the reasons, I suppose, is made clear here. When I go to the court for justice, this is what I get. I'll just show you the letter that I received from the court earlier this week on Monday, informing me that judgment was coming out on Friday. And you'll see at the bottom of this email from the executive officer of the 4 courts, there's a stamp, and it's the broad stamp. It's the transgender pride flag you see here at the very bottom. Now, that's an anti-Christian belief. I'm a Christian. My belief is male and female. God made them male and female. This is something very different. It's the transgender pride flag. It's LGBT. It's not compatible with Christian belief. The two cannot be reconciled. But when I go into the court, of course, I have the Constitution there. I have the law. And that's what those judges have sworn to uphold. But when you get this email, the court is saying that it's a promoter of transgenderism. And that's very wrong. I would say that's just simply not just. The court is supposed to be impartial. It's supposed to be unbiased. Think of Lady Justice, blindfolded. But there's no blindfolding here now. This is just simply laying out that this court will be a promoter of transgenderism. So I believe that's what it goes back to, of course. This ideology, this stamp at the bottom is really just saying this court promotes transgenderism, promotes an anti-Christian ideology. And that has been the problem, of course, from the start. But I say that's not just, it's not right, it's not fair. We need just courts. We need judges who will tell the truth, who will administer justice as it ought to be, and will not punish citizens when they come before the court. So regrettably, that's what's happening. My salary continues to be taken away. My bank account is still empty. That money has not been returned now at €56,000 that has been taken from me. But as we see this development today by the courts, nonetheless to be welcomed.